quiet. Be quiet. Yeah, yeah. It's deep in the school. They're on my way. You rich. What the hell? Oh God. just a I got this. Stop. Let me go to court. Okay, please. I got it. Go ahead. Go ahead. I got it. Yeah.
Yes, Mr. Bell, do you have a question?
Hello?
Yes, sir. Do you have your hand raised?
Oh no, I messed with my phone by mistake,
Oh,
but
okay.
I'm here.
Okay.
This is 2300786 GC. This is Prime Home versus Ronald Rowe and Jeffrey Wilshaw. May I have your appearances, please?
Good morning, Your Honor. Brian Mark, on behalf of defendant Jeffrey Wilshaw.
Mr. Kefferstein? Mr. Kefferstein? Are you able to hear me, sir?
Me?
No, Mr. Bell, you're fine.
I just sent him a chat, Judge.
Thank you. Mr. Bell, while we're waiting for the attorney to figure this out, have you talked to the attorney from Mr. Levine's office?
Yes.
Have you made a payment since the last time we were here?
Yes.
Did the attorney indicate to you that he would be withdrawing his request for an execution?
No, I just got a letter. We worked out something saying I pay $800 by the 31st, and then I emailed it to him. It's $800 on the 31st of May or before, and $475.96 for July, August, September, October, November, December. Like right here.
Was that an agreement you signed and sent back to his office?
Yes, and I'm gonna show you my signature because it's got your will you supposed to sign too right there.
When did you send it back to him, sir?
Yesterday.
Okay, I
I was at
didn't
work.
see it when I reviewed the file yesterday.
I mean,
But was it your?
I can wait. I mean, if you want to talk to, I can wait.
Okay. Okay, I was gonna say, if you don't mind, I'm checking our
I
system
don't
right now
mind
to
at
see if
all.
Miss. Okay. Are you on the phone with him, Marianne, or someone else?
No, I am not.
Mr. Kefferstein? Were you talking to him before?
No, I sent him a chat. Oh, you mean?
No. When he
no.
first logged on.
No, I did not speak with him.
Okay.
So it's just the base comments and everything. So got plenty of yeah. Okay. It's a there.
It might be time to disconnect and see if that helps them. Give it a moment.
Do you want me to remove him, Judge?
I'm waiting to see because he has some support there. I'm wondering if, because it looks like they're connected well. I wonder if it would help to turn their microphone up or something.
Hey, Your Honor,
Yes, sir.
if it's not a problem, if I got you something personally, but without everybody in our conversation, would that be okay?
Everybody's in our conversation. We're recording this and we're streaming on YouTube. Is it something about this case?
Yes.
You can't ask me anything about the case while the other side is not here. I've already checked and I don't see that we received a signed document from Mr. Levine's office, or I think it was Mr. Lamon that was here the last time we were here.
Yeah.
Well, let's try this. Ask me if I can answer it without.
Okay. This the question. I'm gonna pay. They want me to pay 800 on the 31st, right? That's fine. And then they also want to pay additional 900 to Sun Homes. That's like $1,700. And I went up to West Village Estates and told them like, and I got a truck note like, I get paid every 2 weeks. I don't have that much money like that. But she told me as long as I pay them at least 500 or 600, let them know I'm trying to do something. That's fine. But I want to make sure it's okay with you. So she said more important to pay my mortgage first.
Mr. Bell, the thing is, whatever the parties work out between themselves is fine. If it's something I need to make a ruling on, both sides need to be here. So if you
Okay,
sign that
well,
agreement
Renee
with
said,
Mr. Lamon's,
yeah, Renee, Sun Home said, as long as I get it, she told me don't worry, but I'm gonna just do the 800. What he asked me on this paperwork.
if what is on the paperwork does not match the agreement that you have with Ms. Samples, there's a problem. But if the parties reach an agreement and you both sign off showing the court that you agree, I'll sign off and enter it as an order. If you're saying that what Mr. Lamon or Mr. Levine sent you is not what you agreed to with Renee,
No,
that's a different
I did
conversation.
agree. I did agree to that. She told me to pay. She told me to pay my mortgage and agree that I signed that 800 on the 31st. But she said, just give us what you can. Let the courts know like you're trying. You got a son, and you got your truck note, stuff like that. That's Sun Homes. They told me my mortgage is more important than that part. So I just wanted to get clarified a little bit, just a little bit.
Okay.
I will sign off on anything you sign off jointly. Period.
No, I already signed that
Oh,
paper.
I can hear you now to the gentleman with the green shirt. I can hear you from Mr. Kefferstein. Oh, and now you muted yourself.
Yep, I just wanted to, he's taking my chair. I'm sorry.
No, you're fine. Mr. Kefferstein, before you start, this is 2302878GZ Sun Communities versus Bell. Mr. Bell, I don't see Mr. Lamon or Mr. Levine here. This case was scheduled at 9 o'clock. It's now 9:12 by my clock. There was a continuation of a prior motion on an eviction. The parties appeared last time and there was an indication that you made payment of $1,000. You were going to pay another $800 on May 2nd and then another $800 on May the 16th. Before the case was called, you indicated that you signed an agreement with the plaintiff's office to dispose of this matter. Is that correct, sir?
I did.
Based on the attorney's failure to appear this morning on behalf of Sun Communities, the court will deny their request for an execution. The court has noted that there is not a signed agreement yet received by the court. I'll send a note downstairs to the civil department to keep an eye out for it. But Mr. Bell, the court considers this issue resolved.
Do you want me to email you the paperwork I got? Just put it on file?
If it's signed by both parties, there's a,
No,
yes, sir.
just me.
You can do that. Nope.
Just me.
Then if you signed it and sent it back to him, their office will sign it and file it, but I'll leave a review in for myself to make sure that I get it so it's signed and entered by the court, okay?
Yep.
Anything else, Mr. Bell?
No, Your Honor.
Have a good day, sir.
And you have a very blessed day as well. And your family.
Thank you.
Thank you.
So recall 2300786GC Prime Home versus Rowe and Wilshaw. May I have your appearances?
Please go Warren Kifferstein, appearing on behalf of Prime Home, Remod LLC, P 15948.
Sorry, Brian, on behalf of the defendant Jeffrey Wilshaw.
Your Honor, could I break into a breakout room with opposing counsel?
Absolutely.
Thank you.
Thank you. Do the parties need to speak on Gaston Elam versus Gauche?
I haven't had a chance to speak with her, Your Honor, yet.
That's what I just asked. Do the parties need a chance to speak? We can get you moved into a breakout room.
Okay, thank you.
You're welcome.
Good morning, Your Honor.
Good morning, sir.
This is Jeffrey Wilshaw. Is there a chance you could move me into the breakout room with my attorney, please?
Absolutely.
Thank you, ma'am.
You're welcome. Were you expecting Mr. Kifferstein to come back out?
Yes, Mr. Kifferstein is supposed to be back out to the main here.
Here he is. The parties have returned on the Prime Home matter. How are we proceeding this morning?
Well, if I may, we're going to enter into a dismissal of my client, Jeffrey Wilshaw, without prejudice for now, as the case proceeds, and there's nothing further that develops that would in any way suggest that Mr. Wilshaw be brought into the back into the case, which I'm absolutely positive won't happen. But anyway, if it doesn't, then the dismissal will then become with prejudice. We'll submit a separate order for that, and then that would do it.
So the dismissal without prejudice as to defendant number 2, Mr. Wilshaw, that be by stipulation, Mr. Marcus?
Yes, it will be.
So Mr. Marcus, if your office could get that prepared and submitted through the True Filing, OnBase, MyFile, whatever you call it on your end, if you would get that stipulated order executed and submitted, I'd appreciate it greatly.
You got it. Thank you very much.
And as for the remaining defendant, Mr. Kifferstein? Mr. Kifferstein? Mary Ann, I'm not sure what the issue is. There is a remaining defendant in this first case. Mr. Rowe had appeared at a previous hearing date and had not yet filed an answer. Mr. Marcus, I'm not sure if you want to hang around.
Yeah, if I may
See
leave,
if
that
Mr. Kifferstein has some information regarding.
Oh, I'm sorry. I was just saying, I don't think there's anything further for me. If I can leave along with my client, that would be
Absolutely,
just to
sir.
move. Okay. Thank you. Have a
Have
great
a good
day.
day. You too.
Thank you, Your
Mr.
Honor. Greatly
Levine.
appreciate it.
No worries, sir. Take care. Mr. Levine and 2302878 GC, this case was scheduled at 9 o'clock. I called it at 9:12. Mr. Bill indicated that he had signed an agreement to resolve this matter and sent it back to you.
We have a consent judgment. I'm sorry I was late. I called the court to inform you I'd be a little bit late. And we have a proposed consent judgment signed late last evening. I'll e-file it right now. It sets aside
so
the default
much.
judgment and it resolves the motion that's pending and should be a final judgment as long as it performs.
Thank you so very much. If you get that filed, I'll sign and get it back out to the parties.
Thanks,
Anything
Judge.
else this morning?
Nothing else from me. Have a nice day.
You too. Thank you. 023484 GC Brookline Management versus Lane Process Improvement. Your appearance, please. Mr. Cox?
Good morning, Your Honor. Is this the Pickwick Park Association case?
I'm sorry, the what case?
Is this 023484 GC?
Yes, sir.
I'm sorry, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146. I'm sorry, Judge. I got thrown by the name. We have it listed in our system as Pickwick Park Association LLC, and I think it's listed as something different on the pleading, so I apologize.
It's listed as Brookline Management versus Lane Process Improvement with the court.
Judge, this is the time and date set for an adjourned motion to reinstate case that was filed against the garnishee defendant and for entry default judgment against the garnishee defendant. Exactly 2 weeks ago, the parties were here. Mr. Beasley showed up, who is the underlying defendant in the case, and a representative from the employer showed up. We met in the breakout room. I thought things had resolved and that they made a representation regarding his employment status. And we said simply that we needed that reduced to writing. So I emailed Mr. Williams a proposed disclosure, the same disclosure actually that we'd sent him previously, but I emailed them that on May the 7th and then again on May the 17th, and I've not gotten a response. And I think I tried calling Mr. Beasley. No, I called Mr. Williams also and left a voicemail yesterday to see if their intention was to put that into writing. I've not gotten a response. My proposal for today, Judge, is part of our motion is to reinstate the case against the Garnaschee defendant and then enter default judgment. I'd propose that the court enter an order reinstating it today, and either reset this or show cause the Garnaschee defendant for not either filling out the disclosure and or appearing here today. Obviously, if we take a default judgment, I suspect we'll be back here, and that's not my intention. I think we got 80% of where we needed to go last time. But I also think that we need to get that disclosure filled out. So that was what I proposed to the court. We did ask for relief in two forms last time, one to reinstate the case and one for default judgment. I'm asking the court to grant half of that today and set it ahead for the other part.
Thank you. When the parties were last here on May the 7th, Mr. Williams did indicate that he would be able to complete and file with the plaintiff and copy to the court a disclosure within 7 days. When I reviewed the file yesterday evening, I did not see that a disclosure had been filed. This case having been scheduled at 9:15, it now being 9:23 by the court's clock, and neither the original defendant nor the Garnaschee defendant have appeared. The court will grant the request to reinstate this case. And Mr. Cox, I'm not sure if you want to do an order to reinstate with setting a deadline to file the disclosure in the order of reinstatement, or schedule it on the court's next civil docket for entry of default judgment.
I actually, Judge, I like the court's suggestion. I think it might be more efficient. I can do an order to the court today, setting the dismissal aside and ordering the defendant, say, to file a disclosure within 10 days, or default judgment shall enter, or the plaintiff may then submit a default judgment. And we could even do that under the 7-day rule too, if it pleases the court. But I think that might be more efficient. He's obviously been given a lot of opportunity here to come forth and do what's been required of it, and the representation had been made on the record last time.
Thank you. You don't need to do it by 7 day. I'll make a notation that the dismissal is set aside, the case is reinstated. Defendant has 10 days from today's date to file the disclosure, or default judgment will enter. Copy will be mailed to the employer, and we'll see if that prompts a response.
Very good.
Anything else, Mr. Cox?
No, that's it. Thank you, Judge.
Have a good day, sir.
You too. Thank you.
Thank you. Mr. Peterson? Marion, do you know why he's here?
No, I've been trying to get him to go into a breakout room and it's
There are
not
only
happening.
4 cases today. You thought it would be easy. This is
Yeah.
2400879 SC. This is Jamie Gaston Elam versus Gooch and Sons Towing. Would you state your names for the record, please?
I'm Michael Gotch.
Sorry, go ahead.
I'm Michael Gotch from Gotch and Sons Towing.
Gotcha.
And Jamie Gaston Elam.
Elam, thank you. The parties have had the opportunity to go into the breakout room. Is there any resolution of this matter?
Unfortunately, no, Your Honor.
Sir, today's the day and time set for hearing on your motion. Please proceed.
Yeah, Your Honor. At the hearing, I inadvertently put it in my phone as 3 o'clock. As you probably can tell, I showed up on time, 3 o'clock appointment, unwittingly made that mistake. I do have a defense. We did remove that vehicle legally and according to the law and with the permission of the property owner. I'd like the opportunity to be able to show you that.
Did you receive a copy of the plaintiff's response to your motion?
I did, Your Honor.
Okay, in that response, there's representations made that somebody did appear on behalf of your office timely, but then ultimately disappeared. Did you have any response to that allegation, sir?
Well, that wasn't a person from my office. That was the property owner that showed up to the hearing. And she was notified by my secretary that we are having the hearing. The sole blame for me not being on time for the hearing is my own, because I'm the one that entered it into my date planner on my phone. So I gave it to Rebecca to notify the property owner to be at court. And like I said, I made a mistake. I put it in my phone as 3 and not 2. I was on time for 3. I know that doesn't hardly count, but it was just surely a human error. I assure you, I have a I just made a human mistake.
Anything else, sir?
No, Your Honor.
Thank you. Ma'am, your response.
Well, not only has it cost me time again today, but this has caused a lot of problems. They towed the vehicle illegally. My daughter lives in that apartment. They've claimed several different ways and reasons why they've towed this vehicle. First, they said it was an abandoned vehicle. Then the property owner and the tow company said it was towed because it was blocking a fire lane. When I just received these papers that said it was towed because it was abandoned, I have their paper right here that they tagged the vehicle, said it was tagged or towed because it was in a fire lane, blocking a fire lane. I tried to discuss this at the time that it was towed. Nobody wanted to discuss it at that time. I was told then it was because of fire lane. There's just been so much back and forth and miscommunication and not wanting to talk to me then. They shut the window on me then. They wouldn't take my phone calls. I mean, I just don't see any reason why we have to pursue this anymore. It's not my fault that he made a mistake and put the time in wrong. I sent evidence in again. This vehicle was plated, insured, had the residence sticker in it that it was legally parked at the apartment complex, not blocking a fire lane. So neither was it abandoned or blocking a fire lane, which it was in a letter stated from the fire marshal of the township where the vehicle was at. So whether it was listed as abandoned, blocking a fire lane, whatever reason they want to say it was towed, none of those reasons are viable, none of them. So I don't believe that any more of my time should be wasted to go through this case any further.
Thank you. Anything else, sir?
Yeah, Your Honor, there's much more to it than that. According to her contract with her apartment complex, it requires the sticker to be put in a certain spot. Her permit was up in the tent where no one could see it. The pictures will clearly show that it was parked in a fire lane that was identified as a fire lane. Not to mention that she misfiled this case, and the law only allows for a hearing to be made within 20 days. And she filed a small claims, which is barred in this type of case. You can see in my motion, I spelled it all out and how you're supposed to file 20 days, supposed to pay $40. State fees to file this case. It was just misfiled.
Ma'am, that would be if it was an abandoned vehicle. This was not an abandoned vehicle. And as I've received or submitted a letter from the fire marshal from Huron Township, he states there is no fire lane at this property. They went to the property, according to their site plan and the township, there is no fire lane on this property.
Sir, my concern is when you realized on April the 23rd that you were an hour late for the scheduled hearing, what did you do next? Did you call the court? Did you speak
Yes,
to?
I'm sorry to cut you off. Go ahead.
Mm-mm.
I
You can cut me off. Go ahead.
yeah, I'm sorry for that. When I came on at 3 o'clock, the gentleman answered the Zoom, and he's the one that told me, like, you know, this was at 2, not 3. And then I asked him what to do, and he's the one that told me that I needed to go to the court and file this paperwork. So no, I didn't call the court after I spoke to him. He gave me the instructions.
Thank you. Is there anything else, sir?
No, Your Honor.
Thank you. This matter having come before the court on the defendant's request to set aside the default judgment that entered after his failing to appear for mediation, the court will grant the motion and schedule this matter for hearing on the underlying claim. And ma'am, you've indicated that you've now had 2 days of having to appear in this matter. Is there a day of the week or a time of day that's better for you than any other time?
No, I work the same hours as the court, but I'm not understanding why there needs to be another hearing.
Do you want to do the hearing on your claim right now?
I mean, we can.
Do you have all documents and witnesses that you need in this matter, ma'am?
I don't think there's anything different that I need to present. I presented everything to the court that there is to present.
Sir, are you prepared to have a full hearing in this matter this morning?
Unfortunately, I'm not. I need to have the property manager available.
That's the issue, ma'am. Today was just scheduled as the hearing on the motion to set aside the default judgment. And typically when the judgment is set aside, the case is scheduled for a new date. If Mr. Gouch had appeared as ordered for mediation and the parties had been unable to resolve it, it would have been scheduled for a full hearing anyway. So there could have been potentially at least 2 hearings in this matter, the Zoom with the mediation and then the actual hearing on the small claims. Whether you want to do it by Zoom or in person, the court will be as flexible as possible and be mindful of your schedule. And you indicate that you work the same hours of the court, but if there's no day or time that's better than any other day or time?
No, there's not.
Is there a specific time maybe where you take lunch where we could schedule this so that you're not taking off from work or not missing work?
No, there's not, ma'am. I'm an officer. I get called during different times.
I'm looking at June the 4th as a possible date. I'm looking at potentially 1 p.m. by Zoom, unless the parties wish to be in person.
I'm good with that if she is, Your Honor.
That's fine.
And Zoom is fine, unless she wants to go in person. I could do either one.
June the 4th at 1 p.m. by Zoom. It is the only thing that the court will have scheduled. So as soon as the parties appear, we'll be ready to proceed. If you have witnesses other than yourselves, please have them log on timely as well. If the parties reach an agreement and resolve this matter before that date and time, please prepare an order that indicates what that agreement is. If you both sign it and file it, the court will sign it as well. Other than that, I will see you on June the 4th at 1 p.m. Is there anything else, ma'am?
No.
Anything else, sir?
No, but I wanted to extend my apologies for the troubles. I'm sorry to put both of you through this.
Thank you, sir. That concludes this matter. Have a good day. You're both free to go.
Thank you.
Mr. Kifferstein? Sir?
Judge, can you hear me?
I can hear you now.
Good.
Mr. Marcus indicated that there was going to be a stipulation to dismiss his client, Mr. Wilshaw.
That is correct.
And where does that leave us with Mr. Rowe?
That leaves us with a complaint that I would like to amend against Mr. Rowe. I want to add a count of quantum merit.
The issue with that, sir, is I don't see that matter, that request to amend had been noticed, putting Mr. Rowe on notice that it was. Okay.
Can I explain, Judge, what occurred? I made two motions. I sent two motions into the court. One, a motion to amend the complaint regarding Donald Rowe. I wanted to add a count of quantum merit, and I may want to add a count of misrepresentation and fraud. There's another case that's before Tina Brooks Green.
Yes, sir.
I made a motion to reinstate the case because it was dismissed. I could not serve Ashley Sawyer within the allotted time. So I wanted to reinstate the case and then consolidate that case with the case before you now, case 2300786 GC. Both the same property, both defendants would be familiar with the case. Both committed, well, Ashley Sawyer committed breach of contract, fraud, misrepresentation, and Jeffrey, Ronald Rowe, who was her friend, I believe committed quantum, he's responsible for improvements made to his house because of quantum merit and unjust enrichment. I also believe his silence as to who he was and what part he partook in this may lead to fraud and misrepresentation. So I was able to, all three defendants, Ronald Rowe, Jeffrey Wilshaw, and Ashley Sawyer, were avoiding service. I had an order for substituted service. I was able to serve Ronald Rowe and Jeffrey Wilshaw through an order of substituted service. Ronald Rowe was served by first-class mail, certified mail return receipt requested, and posting. Ronald Rowe failed to pick up the certified letter after being sent a notice to do so by the post office. I believe he was served because of posting, and I never received back the first-class letter that was sent to Ronald Rowe. So I assume he got that. And Ashley Sawyer, she's as free as the wind, and I just can't seem to serve her, and I'll ask for a motion for substituted service regarding her, and I'd like to consolidate the cases. And I didn't know.
Respectfully, Mr. Kifferstein, there is a indication in the court's file that there was a filing of a motion to consolidate, and I just saw, give me one
Motion
moment.
to amend the complaint.
Right, I see
Motion to
that there was a
consolidate
proof
and a
of
motion
service.
and there's a
I'm
motion
sorry,
to
sir,
reinstate.
there's a proof of electronic service on a motion to amend complaint that was filed on May the 6th at 12:57 PM. But there is no motion, there's just the electronic proof of service. So I'm not sure what happened to your motion, the motion that's referenced in the proof of electronic service. The only motion that was on this court's, in this particular case that was reviewed was Mr. Marcus's motion for summary disposition. So I'm
Right.
not sure what happened to the motion that's referenced in your proof of electronic service.
So do you want me to refile the motion to amend the complaint regarding Ronald Rowe? And there's the other case is assigned to Judge Green. That was a motion to reinstate and a motion to consolidate.
I saw that in the file that is 23-3549 GC. Judge Green has asked that they be scheduled for hearing on your request to reinstate the Ashley Sawyer matter. But for this case, your motion to amend complaint lists Mr. Marcus as being served, but there's no indication that Mr. Rowe was served. So I would ask that you resubmit the motion with proof of service as to Mr. Rowe. We can get it heard as soon as June the 4th at 9 a.m.
Okay, so you want
I
me
just
to
don't even see the
resubmit the
motion to know
motion
that
to
you're
amend the
adding a count of
complaint?
quantum Merowith. I'm sorry?
You want me to reserve the motion to amend complaint against defendant Ronald Rowe?
Correct, sir, because I don't see that it was served in the first place.
Okay. And then the motion to reinstate and consolidate, was that received by the court?
It was, and Judge Green has already given indication to court staff that that should be scheduled for hearing. I just didn't see that it had actually been scheduled as of yet.
So do I call the clerk of the court to get a date?
I don't know that you might want to follow up with them, but I'm looking at Judge Green's notes and it just asks that they schedule it for hearing.
Okay. So I don't know. My problem is I want to reinstate the cause of action. It was never heard on its merits because there wasn't service. And yet I want to consolidate the cases. I don't know from what judge to the other judge is going to receive the case.
This case this morning appears to be the first file, so I would believe that the consolidation would occur into the first file case.
The case would go with you?
I would think if the request to consolidate were granted, I would think that it would be the oldest case.
Okay. I'll refile the motion to reinstate and consolidate.
Thank you, sir.
Thank you. Have a great day. Sorry, my computer.
No worries.
Fritz.
You're fine. You have a good day.
Have a great day. Stay well.
Thank you. And Mary Ann, that is it for us today. Thank you.
You betcha.